Today we have a very special event. We're doing a deep dive into law and judicial reasoning that should be of interest not only to lawyers, but to philosophers and political theorists. Baron Jonathan Mance is one of the most distinguished and thoughtful jurists in the world. He has led a brilliant and highly interesting career, one dotted with too many accomplishments to try to list here. But I'd like to mention two things about him that I find of interest, since they say something about him as a person. First, he's part of a dynamic power duo. Lord Mance and Lady Arden, who is here, we're very glad to have her here, are the only couple who have served serially on the UK Supreme Court and probably any high court in the Anglophone world. Second, Lord Mance is truly a global jurist. Not only was he former Deputy President of the UK Supreme Court, but he has also served as Chief Justice of the Astana International Financial Center Court in Kazakhstan and continues to serve as an international judge on the Singapore International Commercial Court. I can't think of anyone better placed to give us a deeply practice-based view of both judicial reasoning and the role of law around the world. We are also very fortunate to have two outstanding legal scholars who will be leading the conversation with Lord Mance. We have Oxford's own Professor Rebecca Williams, Professor of Public and Criminal Law, and Professor Jonathan Harris, Professor of International Commercial Law at King's College, London. Welcome, and thank you for leading the session. I now turn the floor over to our conversationalists.
Thank you so much, Ruth. So we wanted to start off by asking you a little bit about your experience of judging and the process of judging and how you go about doing it. And in particular, I couldn't resist really picking up on something that you once said in a speech, which is that the Supreme Court came into existence as part of a back-of-the-envelope plan in 2003, which took some years to straighten out. And I was wondering what you thought needed straightening out and how that was done.
Up until that date, we operated as strictly a committee of the House of Lords, which was a protective institution and was proud of the law lords. And although we weren't strictly a court, we were in philosophical terms, and we operated entirely independently. The idea of a Supreme Court had been floated, partly with concern behind it that, at least in look, we might not look independent. And I remember at the time of the Pinochet affair reading in the Spanish press that our involvement with the political House of Lords might influence the outcome, which was nonsense. But I think the more domestic reason was Tony Blair's desire, previously announced, for constitutional change. The devolve legislation was also part of that. And more personally, the fact that his great mentor, Lord Irvine of Lairg, had proved to attract a very high profile, which wasn't doing the Labour Party any good. Tony Blair conceived the idea that the constitutional potential anomaly and perhaps his personal problems could be solved for once and for all by abolishing the Lord Chancellor, creating a new Supreme Court, and wiping the slate clean. That proved a completely impossible plan overnight, because the Lord Chancellor not only was the head of the Judiciary nominally, but sat as such from time to time, even then, and was a senior minister, but above all was Speaker of the House of Lords, so that without him, the House of Lords couldn't sit politically. And so within 24 hours of the announcement that the office of Lord Chancellor was abolished, it was reinstated, and a new Lord Chancellor, Lord Falconer, turned up to sit in the political House of Lords so that it could operate. What needed sorting out was, of course, a whole range of things like buildings, not least, but also what was our role to be? Was it to be precisely the same? In the event it proved not to be, we took over the devolution jurisdiction which had been exercised by the Privy Council. So we did acquire that, although we did regard ourselves really as the direct successors of the House of Lords, of the Law Lords, and jurisprudentially, although some have suggested that perhaps we were a bit freer, I don't think we thought of ourselves as such. We thought of ourselves in terms of continuity. Methods of appointment had to be decided. Previously it had been the Lord Chancellor, although there had been a huge amount of public scrutiny of how the Lord Chancellor operated. What was introduced under the Constitutional Reform Act after 2 years of labour, which involved, amongst other things, my wife doing a lot of drafting in the Act, because she chaired a committee. What emerged in the Constitutional Reform Act was an entirely independent method of appointment, non-political, which I think has proved very valuable. Judges are involved, but they certainly aren't the predominant group. What else changed? I think we became a rather remarkable institution, a non-ministerial government department, which meant we had our own budget, although it had to be negotiated with the Treasurer. And we were in charge of our own administration in the sense that the Chief Executive, although a civil servant, was appointed by the by the President of the Supreme Court, and strictly so were the other officers of the Supreme Court. Nationwide, the leadership of the judiciary was entrusted in the case of the Supreme Court to the President, and in the case of the English and Welsh system to the Lord Chief Justice. And I think it's a system which has prevailed and proved its worth, and we made it our mission from the outset to make the system, the new system in its new building, transparent. In the House of Lords, we were like mice. We operated upstairs at the end of a long corridor, and we saw one visitor, perhaps, well, maybe 5 a day at the most. Thousands come to the Supreme Court because it has made it a point of outreach. We started broadcasting everything. We announce our judgments not only in summaries, but also oral summaries at the time of the judgment. You can see them all on the web. And we have engaged with universities and schools. And I think, well, I speak in the present because I still feel, in a sense, part of it. It was a very interesting period. I think the court has been a successful court, but of course that's in part for others to judge.
And do you think you'd have made that move towards greater transparency anyway? And was it sort of catalysed by your moving surroundings?
I think the one thing which one could say about the Lords is that the accommodation was distinctly substandard. And I mean, wonderful corridors and wonderful committee rooms, and the chamber is, of course, glorious. And our own rooms were not bad, but the thought of bringing in new technology and so on, it just needed a new building. You needed more space. You needed a place for a press officer and so on. So it wouldn't have worked. I mean, probably one would have tried, but it wouldn't have worked.
Thank you. I was reading an interview you gave a few years ago in Council magazine where you commented that I think you said you'd enjoyed each level at which you'd sat at court level more than the preceding one. I was just wondering how different is it being in the position of going from being a sole judge and making the decisions yourself to having to work collaboratively, and if you can say anything about that process of having to work collaboratively.
Well, I think the secret of first instance judging is actually to think collaboratively there. You've got to get the parties to collaborate with you. In other words, and it's not as difficult as it sounds. They may be at loggerheads with each other, but they are probably, especially in the commercial court, former colleagues or present colleagues, and people you may have known yourself quite well. And it doesn't do them any good, or probably their careers any good, if they get the reputation for not helping the court. And so I found that provided you say to people, look, what's going to help me is your assistance, not your squabbling among yourselves. And all these lawyers' letters, they really don't get you anywhere. They may satisfy your indignation or your clients, but they don't interest me. And provided you can inculcate this spirit of collaboration, I think it exists at first instance. Of course, when you go to the appellate level, you have the fun and the interest of collaborating with colleagues and sometimes trying to make them see things your way. At first instance, you can just do what you decide is right, but at appellate level, you have to sometimes work quite hard. It may be advantageous to even get out a draft very quickly. You stand more chance of influencing someone than if you deliver it fifth after people have delivered their own versions. So there's more scope for psychology and collaboration with colleagues, of course, in the larger court when you go to the top.
And did you find that your mind was equally changed by others frequently?
I mean, frequently it suggests constant changing of mind. Certainly from time to time, one's mind was very much changed. Yes, I can think of judgments which I rewrote as a result of other people's input, and that's the point of exchanging drafts. I think one of them you mentioned in the preparation for this, Kennedy and the Charities Commission. I can remember rewriting parts of that judgment.
One of the things I've heard you speak about in the past is the nature of common law judgments, and in particular in comparison, for example, to a court such as the European Court of Justice, whereas we know you'll get a single judgment, sometimes quite a short single judgment, sometimes quite a short single judgment on an issue that scholars have written at great length about and have been much debated. And then you'll get this sort of short answer. I wondered if you could sort of elaborate on your views on the sort of, well, firstly, really sort of the merits of the common law method of having concurring and dissenting judgments, as opposed to what might be the merits or otherwise of the Court of Justice's style of judicial reasoning.
Well, I think I must first accept that I speak absolutely from within the system. In other words, what I am going to say won't surprise you in the sense that I am a great fan of the common law approach, because I believe that it does what should be done, namely explains the actual reasoning of the court or the judge giving the judgment, and goes into the difficulties as well as the answers the question. And I can amplify that. I think it's fruitful for the development of the law. But secondly, I must add, therefore, that these are different systems based on a different underlying philosophy. I think the continental philosophy, the French, which is inherited in large measure by the Court of Justice, is that the court is a unit, it's an element of the state, it says what the answer is, and that must be accepted by the users. That's a much less deliberative, debating form of exercise. It doesn't seek so much to persuade as to dictate, to decide. They're both methods of decision, and they both ought to yield clear results. And of course, you can criticise some common law judgments on the basis that there are too many judgments and they haven't yielded a single result. And what does the case decide? Of course. But that said, I think personally, to work with a judgment which is fully reasoned is preferable. As I say, I speak from within the system, and more valuable, actually.
Yes, I mean, I think, for example, in a field we're familiar with, international litigation, about all the ink that was spilled on questions like when the UK was a member of the European Union, whether, if proceedings were brought in England against a UK domiciled defendant, whether they could be stayed or not. Enormous amounts of discussion about this, learned decisions from the English courts. and then you get a judgment that's sort of 5 pages long that says, no, you can't do this. I mean, I sometimes think that the reaction, the sort of negative reaction, was as much about the difference in style, that this was quite a complicated problem, and what you've got is quite a short answer to that problem. I mean, was that a fundamental issue, do you think, that the ECJ was just a totally different, essentially a civilian style of reasoning?
Yes, I mean, there have been civilian moves or arguments pour une explication plus explicite. I remember was one of them. I forget who the author was, and that was several decades ago, and they've been repeated. And I think, I mean, the Court of Justice, like all institutions, has developed. It has certainly developed in a way which common law advocates would recognise and welcome. It asks more questions now. It used to be unheard of to ask questions during hearings, so you can have a real argument now, generally at the end of submissions, but also sometimes through interruptions, which is much more a common law style. And I think perhaps what one regrets, I'm an internationalist, and I regret that we no longer play a part in that or can really influence it now. I think it's also unfortunate for the common law at large. I mean, in the world, the common law is if not the great system. In Europe, it's now got tiny representation at European level in the form of Cyprus, Malta, and Ireland. Of course, at the Strasbourg level, human rights, we are still very much members and have, I think, proved very influential there in their style and approach and their substance too.
And in fact, it wasn't just court decisions. I mean, the UK had a special position, for example, in the field of international litigation, and was very influential because it had a right to opt in or not to particular initiatives, and that gave it a lot of negotiating power. A lot of the regulations, actually, you could see the common law influence very, very strongly in them, which obviously is not going to be present in subsequent iterations of those regulations and new regulations.
Yes, we were hugely successful. I don't think people realise how influential we have been inside both Strasbourg and the European Union system, but the one which Jonathan and I know best is, of course, the hugely successful move to renew and modify, restate the Brussels Convention in about 2012, which really ironed out some serious difficulties with it very successfully.
Yeah, and actually, if you look back sort of 30, 40 years ago, people were saying, what is this new European regime? You know, it's not the way we've done things in the common law jurisdiction. And then you fast forward 35 years and people are saying, how can we manage without this system? You know, because, you know, both we'd become familiar with it, it worked, and the common law had been very influential, I think.
But we are managing without it, I understand.
So it seems. Sorry, Rebecca.
Well, so if I pick up on two things that we talked about so far, one of which is our relationship with the EU and ECHR reasoning, and the other of which is that all the public lawyers in the room there is will have pricked up when you said Kennedy. So I can't avoid the opportunity to ask you about this. So to anybody who's not familiar with this, of course, this is the question of when English administrative law can reach into the actual decision of the executive rather than just, as it normally does, the way in which that decision was reached. So while we mostly focus on the procedure used for making the decision, occasionally English administrative law will look at actually the decision taken. And traditionally this was only done using the very high-level Wednesbury doctrine that only if it was so unreasonable, no reasonable minister could have reached that decision would the courts be justified in challenging it. And of course, as we were increasingly familiar with ECHR and EU jurisprudence, then we came across the concept of proportionality itself actually found also in the common law, but to a greater extent. And this, of course, raised the question of when we should stick with our old Wednesbury and when we should move to the European concept of proportionality with its more structured questions about whether a sledgehammer had been used to crack a nut or whether there was a causal connection between means and ends. And this, of course, was the subject of a series of famous judgments. And you, I think, drawing on your knowledge and experience of German and other systems, take a view, which I have to say I personally share, that actually there isn't a huge amount of daylight between Wednesbury reasoning and proportionality reasoning, such that they were really doing a very similar job but under different labels. Whereas some of your colleagues on the Supreme Court took a very different view and thought that it would be a major constitutional change to shift from the one to the other, which would require a much bigger formation of court to do. Since then, it feels a little bit like that debate has gone quieter, and I wondered whether that was because, in fact, there really wasn't that much of a debate to be had in practice, or whether there was another reason for it, and if you'd like to talk a little bit more about your thinking in those cases.
Yes, I can't explain why it's gone quieter, but that's also my impression. I was personally influenced by the very fruitful exchanges that the Supreme Court used to have with the German Constitutional Court. And we became friends with a number of members of the German Constitutional Court, and still are with them, mostly in retirement now. But one of them, Professor Gertrude Lübbe-Wolf, was particularly interested in this area, and had explained in reasoning in some of their decisions that proportionality shouldn't be understood as a rigid, close inquiry in every context. Its application, it was intended as a framework to direct your mind to relevant factors, but its application could, of course, take account in particular circumstances of, for example, the need to give huge weight to the choice of democratically elected politicians, etc., etc. And it struck me that this principle, which I referred to in, I think, Kennedy, and certainly probably also in a case called Pham about the right to a passport or citizenship, this idea seemed to me transportable, especially, of course, in the rights context, because there, even at common law, we recognize the importance of human rights, and that was the case before the Human Rights Act, even though it proved not to go quite as far as the Strasbourg concept proved. So it seemed to me that one could argue that it would be valuable to try and assimilate the systems, and that in certain areas it was very difficult to see how they would differ anyway. I mean, if you are talking about people's freedom or their liberty, their right to reside in a place where they've lived all their lives, you are talking about fundamentals, and it would be odd if the common law didn't take a broadly similar approach to what is actually the Strasbourg approach. And in Kennedy, we were actually concerned with the right to information about inquiries by the Charities Commission, and the whole court came to the conclusion, mainly in reasoning given by myself and Lord Toulson, that actually here there wasn't going to be any great difference between the reasoning which the Strasbourg court would adopt and the reasoning which the common law would adopt, because, and I thought that proportionality was really what we were likely to do at common law in that context. And certainly in Pham, where you're concerned with a person's right to reside in a particular part of the world, that is an absolute fundamental. And again, I thought that it would be very odd if the common law didn't reason in roughly the same way as the German law. In other areas, I accept that there hasn't been that suggestion, even if you might read it into my judgment. It hasn't really been generally accepted. In other areas, I would accept that maybe, as Gertrude Lübbe-Wolf said, the level of intrusive inquiry will be less.
And so 2 questions really following on from that. First of all, does it need, as I think it's Tom Hickman has put it, a rights motor to work proportionality, or might it be that even in cases where there isn't something that you can conceptualise as a right, just the idea of looking at the causal connection between means and ends, or saying, well, has a sledgehammer been used to crack a nut here, that those are actually questions which are inherent in the rationality reasoning, but also central to what it might be to use proportionality?
Well, I think it might be difficult to think of an example which didn't involve some form of right, but I suspect what you have in mind is something which isn't a human right, a personal right. But But I think in theory, even if you're dealing with absolutely basic sort of rights, property or something like that, then proportionality, the questions could be operated.
And a sort of related question really is that very often, I think, as you've indicated, the idea is that proportionality is seen as a more intrusive or more intensive form of review. And actually, in systems which use it across the board, it isn't always, as you've said, it can have sort of deference built in. But I wonder if there's a kind of path dependency that sometimes the judges who see it as a more intrusive form of review have only ever seen it operating in that way. And if you've only ever seen something operating in one particular way, it's hard to envisage that it could be different. Whereas judges who have had more experience of broader legal systems are able to sort of more easily say, well, no, it can do that, but it can also be used in this less intensive fashion. And whether that sort of comparative experience really helps there.
I'm sure there's an element of what you know, and if you don't know it, then perhaps you stick, unless there's some good reason, with what you know. It just happens that the proportionality really comes out normally in cases where there is some personal right, a human right, and in other areas, if you're just dealing with bog standard property dispute, maybe it doesn't. Although it, as you say, could be used as a framework,
yes,
if you were familiar with it.
I think we're sort of moving on to sort of think perhaps about the subject of the role of courts and the limits of justiciability. And I think we're both interested in different aspects of that subject. One obvious area that you've had to grapple with in the international sort of context is the limits, or the proper limits, to courts getting involved in and ruling on allegations of wrongdoing by the UK government or by foreign states or governments in relation to actions that occur in overseas jurisdictions. So I'm thinking particularly of your judgment in the Belhaj case. For the benefit of those not familiar, I think it was 2 joint cases, but the first case, just to give some factual background, Belhaj, 2 parties were, I think, Libyan and Moroccan parties, and they brought proceedings seeking declarations of illegality and damages, and they alleged that ministers, officials, departments and agencies of the UK government had participated in the unlawful abduction and removal to Libya, where they were mistreated and tortured by agents of Libya and the US, alleged to be with the defendant's collusion. I wonder if you could say something both about the judgment, but how you approach that as a matter of principle. What is the proper province of a court to rule on these sort of questions at all, or to get involved in this sort of allegation of wrongdoing?
Well, we deal with it under the heading of justiciability, and traditionally there have developed certain areas which are non-justiciable, and a dispute about a purely international issue, the meaning of a treaty without, as we put it, any domestic foothold, is something which courts won't engage in. On the other hand, there is quite often some domestic foothold. In other words, a domestic right may actually depend upon the meaning of an international instrument. So that's one aspect. Another aspect is that there are certain acts, particularly at the international level, which courts regard as outside their competence, or at least as acts which they will refrain from adjudicating upon. Outside their competence, the classic example is acts within the royal prerogative at the foreign level. It used to be thought that acts within the royal prerogative were generally non-justiciable, but that was exploded in the Civil Service Unions case in the 80s by the House of Lords. That was a case about the government's refusal to allow workers at the Cheltenham GCHQ, the information gathering organisation, to be union members. And the court held that in principle that was a justiciable issue, but on the facts it was reasonable to refuse them permission to unionize. And after that, the royal prerogative has become much more susceptible to review, including at the international level. I mean, courts have told the Ministry of the Foreign Office to take further steps at the international level, for example, to try and reinforce the rights of people in Guantanamo or and that sort of thing. But nonetheless, there are certain acts which are still not justiciable. The classic example is an act of the British government abroad, an act of state, for example, a military move, is in principle non-justiciable. Even it's probably the case if it's against a British citizen, and that's open to argument. And of course, that has been cut across by the Human Rights Act, because in cases where the British Army was in control of parts of Afghanistan or Iraq, their activities, it's been held by the European Court, and we followed that in the Supreme Court, have been held to be justiciable if, for example, they didn't detain people correctly or give them right access to legal advice, etc., etc. Another class of possibly non-justiciable acts are acts by, well, actually non-justiciable are acts by a foreign government under its domestic legislation. The old example there would be the confiscation by the Russian Soviet revolutionaries in the 1920s of assets in Russia, in the Soviet Union. Or acts, it's recently been held, any act done by a foreign government within its own jurisdiction, that has been held to be non-challengeable. In a case called, in Belhaj, I actually thought that that principle was limited to acts in relation to property, confiscation of property. But in the recent, very interesting case, extraordinary case, between the Maduro board of government in Venezuela and the Guaido board of government in Venezuela, it was held that Mr. Guaido was the state, the president representing the state, and that his acts couldn't be challenged. He'd purported to appoint people to look after some gold in the Bank of England in London, I think. Anyway, his acts were held to be unchallengeable under the Act of State doctrine, so they went further than I would have gone. They introduced an interesting caveat, an important caveat. They were valid so long as they hadn't been set aside by the local judiciary. Now, of course, in Venezuela, it's highly likely that the local judiciary would set them aside. So they introduced a qualification on the qualification by saying that provided that the local judiciary was operating independently, and they remitted the question whether it was operating independently to the commercial court. So there's an interesting elaboration. But you can just take it one stage further. It's also arguable that there is a third category of case, which is basically, let me just see how it was put. Well, I think it was really, there are two actually. One is non-justiciability because it involves something like an act of war. I think you come back to the first one in a sense. The fourth one, which I think is very questionable, is non-justiciability because it would embarrass the British government. But that requires a certificate from the Foreign Office before courts will take notice.
Yes, I think there was some discussion in Belhaj and subsequently, particularly in relation to those second and third categories, about whether there's also some kind of public policy exception to the non-justiciability. How does one deal with a public policy exception whilst staying politically neutral? I mean, what constitutes something that is contrary to, so offensive that is contrary to English public policy? Or
there definitely is this public policy, and I applied it at first instance, and it was upheld in the House of Lords in a case about Saddam Hussein's confiscation of the Kuwait air fleet after the invasion of Kuwait. And that led to some long-lasting litigation between the Kuwaiti government, effectively, and the Iraqi Airways. And the Iraqi defense was that what we did was authorized by legislation of the Iraqi government. The planes were in Iraq, and therefore you'll fall within the first and possibly the second principle, both principles. And we said no, because it was so plain that this was contrary to United Nations resolutions, which were breached by the invasion and by the continued detention of the fleet. And so there are exceptions. If it's, but I agree, the border is not entirely easy. I mean, supposing you had an arguable case, I suppose lines are always difficult to draw, but in a clear case of breach of international law, yes, you wouldn't apply the Act of State doctrine.
So just sort of linking from that to looking in a little bit more detail, as we will in a minute, at the sort of justiciability line in domestic judgments. I have the sense in what you're saying that you, although obviously there clearly are still zones where the court will not tread, there is perhaps a sense there, and even more so domestically, since GCHQ, which is the case you mentioned, and also the Belmarsh case, that what Murray Hunt's called sort of spatial deference is less of a consideration now, in the sense that there are areas which are just completely off the table, and that instead courts will more often say, well, in principle it might be reviewable, but, you know, subject to incredible levels of deference to a point which is almost the same. And I just wondered if that is in fact your impression, that we have moved away domestically from those sort of no-fly zones that we might still have extra domestically.
Yes, I think that the deference to the royal prerogative is a high-flown expression, but one must remember that the royal prerogative is actually, in most cases, and if not all, simply an administrative or executive act. And in principle, courts are there to review, in appropriate cases, the acts of the executive, and they are one of the great checks on our executive. And to take a recent example, if you take the second Miller case, in which my wife was sat, that is a case where the court reviewed the prime ministerial prerogative decision to advise Her Majesty to prorogue Parliament. And the court said that that was eminently reviewable. The Queen was simply a medium or a cipher to give effect to the Prime Minister's executive decision. And even if he's acting under the royal prerogative, it's still reviewable.
And just to sort of trace that line a bit more, you've previously said that issues of things like liberty, freedom of movement, speech and religion, those do fall within court special expertise, whereas issues about things like the use of public resources or economic judgment, and on those the elected legislature or executive is better placed. And I was just interested in whether that was a sort of substantive difference, in the sense that it's just knowledge of the subject area that's different, or is there a kind of procedural difference of the kind that John Laws has suggested, where if it's an issue that concerns minorities, a majoritarian system is by definition not going to be able to protect that, and therefore it has to be for the courts. So is it a kind of substantive line, or a more of a procedural one in terms of who else will be able to do the job?
I would say it's both. Undoubtedly there is a procedural aspect, because in majoritarian situations, as a matter of fact, it is less likely or that the rights of the minority will necessarily be recognised and protected. But there's also a substantive element in a decision whether something is reviewable or should be reviewed, which is whether this is something with which courts are really equipped to deal. And courts do have, I hope, an understanding of what personal liberty means and what equality involves, even if one's actually talking about equality of distribution of monies, whether women and men are receiving the same pension rights, or the same state benefits, one of the cases we had. But there are equally cases where actually courts don't feel very well equipped. They probably haven't got the research basis or necessarily the experience. And the issue is whether to build a school or a road. That is the sort of decision which has a political element as to which you value most. A few years ago, we might have valued a road, I gather, through the heart of Hampstead and across where we live, and across Regent's Park, I think, in order to join the Inner London motorway. That was a very high political value. Thank goodness that value has now been recognised as rather low, and we've preserved both Hampstead Heath and Regent's Park.
I suppose I wonder, at the risk of asking a provocative question, we talk about the separation of powers from a court's perspective. I just wonder if you have any observations in terms of ensuring that the legislature observes that separation of powers. And perhaps also a sort of related question, there has been in some quarters from politicians quite forceful criticism of the judiciary in recent years, and how you feel about that, and whether you think it's entirely a matter for them or there are limits to what is appropriate in terms of judicial criticism.
Yes, I don't think judges should be too worried about comments, especially from losing parties. But it is true that political comment can be unhelpful. And I think the present government actually recognises that a lot of the problem we have with our overcrowded prisons today is due to the fact that over the last 30 years, since I think Michael Howard, in maybe 25 years, became a Minister of Justice, governments have, by their comments, encouraged more stringent sentencing. Prison works. And the result of that is, as we know, we have more people in prison in this country than, in percentage terms, than anyone else in Europe. And they've actually had to get to the point of releasing people early. So political comment can be, I think, unhelpful in that sort of area, particularly. As to relations with the legislature, again, I think there have been occasions, I don't want to be too political, where there's been unhelpful legislative proposals, usually because the legislature is driven under our system with the first past the post election of MPs by a government with a majority which can put through its views through Parliament, even if they aren't majoritarian views in the country. But a good example, having sat through the debates on the Safe to Rwanda bill earlier this year, is that I think that was a case where, a situation where I think it's extremely unfortunate that legislation was pushed through, which really ran contrary to my perception, at any rate, of the rule of law, by effectively introducing a fiction, a statutory fiction, that Rwanda was safe, even though it had been just decided that it wasn't, and indeed the House of Lords itself had resolved that it wasn't. And there'd been clearly insufficient time to make sure that it was, and it was going to be a presumption. Well, it was not just a presumption, a binding statement that Rwanda was safe, apparently indefinitely. Whatever happened, you would have had to have another statute to remove the section. Well, that legislation has gone, and I think it was a particularly unfortunate piece of legislation. But it was introduced. It was supported again by Lord Howard. I heard him speak in a speech where he said the Supreme Court's decision was just an opinion, and I got as good an opinion as anyone, and I'm entitled to express it in statutory language. I don't think that is a very healthy constitutional philosophy.
And again, I don't want to sort of ask you about anything specific that you don't want to comment on, but going forward structurally, how do we sort of maintain that separation of powers? And I'm thinking now about things like funding, or about the makes a difference rule, or any of the kind of more structural, logistical pieces of legislation which have sought to sort of alter that boundary of separation of powers?
Well, I think that the constitutional system we have in this country works best when there is a mutual respect, and in general there has been this. We may have had some departures, but under our informal constitution, we rely on what Lord Hope, in the case of Jackson and the Attorney General, was a system where bees work together the institutions of state work together like bees in a beehive. I've always rather liked the simile. But it does, I'm afraid, depend on a personal level. Now, part of what the Supreme Court does is try to explain itself to politicians, and the President and Deputy President go along to parliamentary committees and will explain what they've been doing and answering questions. They're not expecting arguments about the results, but it is an attempt to give confidence to the political institutions that the courts are functioning as they should.
Sort of moving on, or perhaps slightly moving back as well, to talk about international dispute resolution, both in England and in other courts with which you have experience. There was obviously, in the aftermath of the Brexit vote, there was a lot of soul searching from the legal community about what this meant for the future of legal services in England. Contentious proceedings. Would fewer people choose to litigate in the English courts, for example, because the automatic ability to enforce an English judgment against a debtor around the European Union was to be lost? And we saw, I think not coincidentally, in the aftermath of that vote, the emergence of commercial courts in civil law jurisdictions. I'm thinking of it, the Paris Commercial Court, the court in the Netherlands Commercial Court, operating and offering services in England, and effectively marketing themselves, saying, well, we offer a common law kind of system, but you'll still be able to export your judgment around Europe, whereas if you litigate in London, you won't. How significant is the challenge from other jurisdictions, and how much should we be concerned, if you like, about not having those regimes of mutual judicial cooperation with Europe anymore?
Jonathan, you and I sit on a committee which is told, in fact, that the city is not too worried, the legal city, by the absence of the EU mechanisms for coordinating legal systems. We have fallen back on the Hague Conventions. There is in the Hague Conventions some valuable material which actually will apply as against other European Union states, as well as against the world at large. And so personally, I haven't heard any general concern about the loss of the mechanisms with which, as you said earlier, we have got rather familiar over 30 years, which now have suddenly disappeared. The main concern of London as a world legal centre is that its jurisdiction clauses should be observed, i.e. choice of London as a centre, or choice of London as an arbitration centre, should be observed. And in a sense, we've gained some tools to ensure that it is observed where it's made. Under the Brussels regime, we couldn't issue anti-suit injunctions to restrain inappropriate proceedings in other European Union states. In the absence of the Brussels Convention or regulation, we're now able to issue such injunctions, not just against non-EU, but also against European Union states. So the advantages and disadvantages haven't only moved in one direction. And I'm pretty confident myself that London remains, despite the emergence of other courts elsewhere, a highly attractive resolution place for high-value disputes. I mean, one criticism I think one can make of the English legal system, and it's probably not unique to the English, but I think, for example, the German might come off better, is that litigation is affordable only by the well-off. And I fear there is an element of truth in that, which one ought to be worried about. But it certainly is a very efficient system for those who can afford to pay for it. And similarly, in arbitration, London remains very attractive. Having said all that, I think every jurisdiction must earn its worth, and we shouldn't be afraid of competition. And there are competitors. I've no doubt that the Singapore courts, where I sit, as you heard, as a part-time judge, have drawn some business away. I wouldn't have thought very much. Most of their business is Eastern oriented, but maybe some of it would have come to London, but we shouldn't be worried about that. What we should be worried about is if we're not operating an efficient service, and I think we are, but as I said, we may be open to concern if one's talking about lesser value cases and domestic litigation.
Even so, there's an interesting tension. It sort of reminds me of the US political scene, really, because we had sat on our committee and seen ever more harmonisation initiatives for globalisation. I'd taken it as read that it was seen as a good thing that the UK should be party to more and more common rules on jurisdiction of courts, enforcing judgments, taking evidence, all of these things, and that this was all good for business. And then for the first time, I suppose it was obvious, but it struck me that the conversations I was having in the post-Brexit years were about how do we protect our market for legal services in this country. And as you said, there are some advantages to regaining powers that other countries, for example, in the European Union, don't have because they have harmonised their rules together. The UK is busy ratifying international conventions like the Hague Convention on Choice of Court Agreements to protect English jurisdiction clauses. This year ratified the Hague Judgments Convention to re-establish a regime for mutual enforcement with other contracting states, including in the EU. But I wonder, is there some tension between sort of the desire, and if one goes, as you know, to academic conferences, you hear a lot about all the merits of harmonisation. Is there any tension between that and globalisation, and on the other hand, the desire to protect the market for legal services in England and Wales?
That's an interesting question. I think that I am an internationalist in the sense that I would like to be party, this country to be party to instruments which encourage other countries to adhere to certain standards and be recognised if they do. That is one element of the Hague Conventions. On the other hand, I'm certainly also proud of the fact that, and I think it's probably an inevitable fact, that legal centres will develop and offer expertise. And it is also true that that has been encouraged by expanding the scope of jurisdiction, as we're at present free to do, which courts can exercise in internationally connected matters. So there is a certain tension between internationalisation, I think, and equally concern and interest that the UK jurisdiction should flourish. It may be that in certain circumstances it's worth giving up some of our jurisdiction if we could achieve greater recognition of English judgments abroad, for example, but I'm not sure that that's a real problem. I mean, very often English judgments are enforceable through recognised jurisdictions like the UK itself or America, without need to go to other countries where you might have to rely on recognition treaties or the Hague Conventions. So, no, I mean, I think it is inevitable, really, that certain jurisdictions develop and become international centres. I wouldn't unscramble that, but equally I would wish to encourage, and I hope that British lawyers do engage in a certain degree of outreach with other countries in order to help them develop their legal systems in a way which will make them acceptable and may in the end make it worthwhile for us to recognise them as partners in things like the Hague Conventions.
And in terms of outreach, Professor Chang mentioned at the beginning your role, you were the Chief Justice of the Astana International Financial Centres Court. I wonder if you could just tell us, I'm conscious we don't have a lot of time, but something about that role and the challenges that are raised and the opportunities for that court.
Well, that was a very interesting court. It had exclusive jurisdiction in two respects. Firstly, over the affairs of the Astana International Financial Centre, which were not many. I mean, that included things like agreements made on the centre market or employment contracts. But secondly, over any cases which both parties agreed to submit to the court. So that was completely general. Subject to my control as Chief Justice, I could refuse to accept a case on the grounds it was inappropriate, and we couldn't accept, for example, administrative law or tax cases. And it was an extremely interesting exercise. I mean, we got quite a lot of business by the time I ceased on age grounds to be Chief Justice. We had a lot of investment disputes, construction disputes, and that sort of issue, financial disputes. And it was of constitutional interest because one was drawing the borderline between the activities of the court and the activities of the national courts. We had our own separate constitution, so we were entirely independent. We had an internal appeal system with no further recourse. The government had to enforce our judgments because otherwise we would have gone home, as they knew. And there were nonetheless some interesting borderline issues. For example, in one case, insofar as we recognised or reviewed appeal arbitration awards, were we bound to apply the National Arbitration Act? And we held no, we weren't, because we were a separate system with our own jurisdictional requirements, and they didn't include the National Arbitration Act. They included our own arbitration rules. And similarly, in another case, we had a case where two parties were very keen to litigate in front of us, although it appeared in truth, they weren't really at odds. And so I asked why. And they said, well, because the result of this litigation will affect the tax authorities, and we worried about ever succeeding against the tax authorities in the ordinary courts. They actually said that in open court, so I can repeat it. I thought it was a great tribute to freedom of speech in Kazakhstan. And so I'm afraid at the end of the day, I had to say to them, the tax authority refuses to come here. Why should I decide what is effectively an artificial issue which you don't really disagree on, when your sole purpose is to present the answer to the tax authority, who are most unlikely to accept it from me if they're not party to the litigation? And so I refused to take the case. But there were some interesting constitutional matters. There was somebody else who came along, having been refused enforcement of an English judgment by the Kazakh courts. He then came to our court and said, well, you recognise it, which would have had the same effect of making it enforceable in Kazakhstan. And again, one had to look at the constitutional structure of the court, and we decided that that simply wasn't a move which was open. We didn't have jurisdiction to deal with that sort of issue.
So if we stick with this sort of idea of looking forward to the kind of new challenges that the courts are facing in the current era, obviously the one that sort of springs to mind immediately is digital tech. And first of all, I wanted to ask you, you mentioned a moment ago things like access to justice and prohibitive costs, and digital tech is very often floated as a sort of potential solution to this problem in various different ways. And I wondered what you thought about that and whether it does in fact pose such a sort of solution.
Well, it may do give some assistance, and obviously great strides have been made in the digital area to try and eliminate or identify and eliminate biases, which is one of the big problems. And indeed, the invention of non-existent cases, as we know from some recent American experience. But I honestly am not sufficiently involved in the tech world to know how it will work. I mean, would I gain assistance from AI? Yes, in the sense that I use it constantly to research. But would I gain assistance by giving a set of submissions to a machine and asking it to answer the question? At the moment, the answer is I wouldn't dream of even trying. So, but there may be people who are more optimistic about AI, and I know, again, my wife is extremely interested in it, so that maybe she'll be telling me that I'm old-fashioned and doing it the wrong way.
I'm told there are, in fact, you were telling me a little bit about this, programs evolving that can help people predict what the likely outcome of their dispute is going to be. I wonder whether this might eliminate, some cost element of people saying, fair enough, this is what a judge is likely to decide.
Well, I do know there is a program called AI, which is Arbitrators Intelligence, which feeds in the supposed habits or mind thought patterns of arbitrators and enables you to decide whether they are likely to be good to a point in your case. So it seems to me that is a bizarre system, presumably also self-cancelling. You must pay a lot of money one side, but then the other side, will have to pay equal amount of money to get the opposite result. So the two arbitrators should cancel each other out. But I'm not sure that it really is a very valuable thing to try to do, because I think it's generally very dangerous to try and generalize about people's proclivities or attitudes, though in some cases one can.
I should say, actually, French law has banned judicial analytics, so it's not possible to do that kind of job. It's prohibited. And so that's the sort of tech for law, in the sense of will tech have an impact on the way in which law is practiced or carried out. But of course, there's the flip side of that as well. There's law for tech, and the extent to which our existing rules, which were built for interhuman interactions and disputes arising from human interactions, are going to be able to deal with disputes arising from algorithmic interactions, so algorithmic collusion or automated decision making rather than executive decision making by government and so on. And so, are you confident that the common law that we have, that we were talking about earlier, can keep pace with that, and that the principles that we already have are going to be sufficient as judges increasingly have to grapple with those digital disputes rather than human disputes?
Well, I'm not confident that they are yet, and I think that they require, these situations will require further thought and some development, probably, of new principles. And I know why you're asking me the question, because you may have come across, I don't know whether any of you have, a wonderful case called Coin, Quoine, which is a case we had in the Singapore Court of Appeal, and 5 of us sat, and I was the sole dissentient. And the case was about a contract made in the middle of the night by 2 computers operating according to algorithms. Unfortunately, one of the computers had, due to a programming mistake during an overhaul, been cut off from the main web. And it therefore came to the conclusion that there was no longer any market in this was a contract for the exchange of virtual currencies. And it came to the conclusion there was no longer any market for one of the currencies. At the same time, it was instructed that it had to close out someone's position. That was algorithmically determined because of certain shortfall. And so what it did was it went out as far as it could into the world and looked for any old offer because it thought there was no market price. And there was another computer which had been programmed, heaven knows with what intentions, but this might have been investigated a bit more, to throw out ludicrous random offers from time to time. And it happened that there was a ludicrous random offer floating around. And so this poor computer, which had been cut off from the World Wide Web and thought it had to find a contract, whatever level, grabbed this random offer, which proved to be for the sale of Bitcoin at, I forget what the percentage was, but it was some 1/250th of the actual market price. It was a multi-million loss-making contract. When the lucky winner, the person who was programming the computer to accept random offers or to emit random offers, woke up next morning and saw that, heavens, one of my random offers has been accepted. Wonderful. Buying Bitcoin at 1/250th of the price, he sent an actual email message to the computer platform, to the platform on which these deals were being done, saying, major database breakdown, please investigate. Well, he rapidly repented of that attitude and thereafter said that this was an absolutely legitimate and definitely binding contract and no problems at all. Well, I thought that in those circumstances, since if this had happened between real people, one would obviously have said that neither party kind of thought that this was a contract that the other party was intending to make. And I thought one should impute to the two computers that sort of thinking. In other words, if the contract was so obviously balmy that no real person could ever have thought that it was anything but a mistake, then it should be set aside on principles of equitable mistake, which apply in Singapore. They don't apply in quite the same way in England and Wales. But slightly, I won't say to my surprise, but anyway, slightly to my disappointment, I didn't find any adherence to this view, and so I ended up dissenting, and the main judgment is to the effect that, sorry, there's a contract and bad luck, pay up. So I said there really what you're saying, that this was a case where you had to apply the common law. The common law is extremely familiar with operating by reference to the standard of a reasonable man, or person, I shouldn't say man. It's one of these standards which is basic. I mean, giving effect to the expectations of reasonable persons is a theme which runs through large areas of law. It runs through administrative law, it runs through commercial law, contract law, private law. And I thought this was a classic situation where a new, you weren't really recognizing anything new. You were saying, accepting that in a context where no one in their right minds could have thought that anyone would intend this, and everyone would realize that it was a mistake, you should be able to unscramble what happened, as long, of course, as third parties hadn't gained an interest in the meanwhile. If third parties had gained an interest, if it had not been capable of being unscrambled, that would have been different. Anyway, that's why dissenting judgments are important, I think. They are a sign for the future that there may be room for reconsideration. There may be, I mean, that was a case black and white, but there are cases where dissenting judgments add nuance. They enable people to see the limits or the possible limits of what the majority are deciding. And that's why, I mean, coming back to the continental theme you asked me about, it's one reason why I think our freedom to express ourselves as individuals, as judges, is so important. It shouldn't be abused. You shouldn't dissent in every case just because you don't quite like the way the majority put it. But you are entitled to try and delimit or to inspire for the future. And I think that's one of the great features of the common law. And it happens. I mean, cases are reconsidered, points are reconsidered.
Thank you. Ruth, I think you wanted back again.
On that perfect ending, now can we just thank our three panelists and especially Lord Mance for fabulous conversation.